We saw sparks again at the Ninth Circuit, this time at an en banc panel between two judges. This is the Duncan v. Bonta case challenging the magazine bans in California. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, long awaited. We finally got oral arguments for Duncan v. Bonta at the Ninth Circuit en banc panel after some of the weird stuff that we talked about prior, skipping the three-judge panel after the decision from Judge Benitez. Here to talk us through it is lead counsel on this case. She's also a partner at Michelle & Associates. That is Anna Barver. Anna, thank you for being with us today.
I'm happy to be here. Thank you for having me.
Absolutely. But guys, before we get into that today, it is working. So please be sure to like, share, and subscribe to these videos. Hit that little notification bell so that you get notified as we put them out. As always, we want everybody to be as educated as possible on Second Amendment litigation, legislation, and what is happening with the culture in California as they head to the ballot box in November for the general election. So Anna, we had a fiery morning yesterday morning, and I wanted to square a couple things away with you today on this case. First and foremost, at least getting as close to the argument as you can. Can we just sort of summarize? We've summarized Duncan v. Bonta several times in past videos. And guys, actually, Jacob, if you want to drop a link to a past video that really summarizes Duncan in its entirety up to this point, you can go ahead and find it there. But I thought maybe today we could do that contextually with the Heller case versus what we have now with Bruen. Surely at the federal district court as well as the Ninth Circuit three-judge panel, we got favorable decisions with using Heller as the scope. We did not get a favorable decision at the Ninth Circuit en banc. Here under Bruen, we got another favorable decision in the Ninth Circuit, or not the Ninth Circuit, sorry, the Federal District Court. Here we are again at the Ninth Circuit, but can you kind of summarize what kind of arguments are we seeing similar or different really under the scope of these two cases as precedent that we see?
I think that's a good question. I think that in the space between Heller and Bruen, we saw the lower courts kind of coming together under this tiers of scrutiny approach where, there's strict scrutiny, intermediate scrutiny, and because they were trying to uphold, many courts were trying to uphold gun control laws, we saw a lot of courts coming in on intermediate scrutiny, and they were sort of settling around that in most cases. And so now with Bruen, even though I think that Heller never, blessed this tiers of scrutiny that those courts were applying. But I think Bruen came in and the Supreme Court was very, very clear that that tiers of scrutiny approach is not appropriate in Second Amendment and probably many types of cases. And so they put out this, made very clear that Second Amendment cases are to be decided under a history and tradition-based approach. And so what we now are having is state governments that are trying to defend their gun control laws and courts that are trying to uphold them are now, I think, fighting against holding the burden to the state to its burden to establish that its law can be justified by looking at history and tradition. And so we are getting to this weird place where we have to argue that there is this actual first step under Bruen. We don't think it's a step. We believe that we look at the text, and if the conduct that is being regulated by a law is implicated by the plain text of the Second Amendment, that it's presumptively protected, and the state needs to establish with history and tradition that its law can be justified. But now we see the courts saying, no, there's this first step, and it's plaintiff's burden to establish that the Second Amendment is actually implicated. That might look like it has to be a severe burden, which we saw in the B&L gun show cases, or what we saw yesterday, which in Duncan, which is are magazines over 10 rounds, actually arms that get some sort of Second Amendment protection, requiring then the government to establish with history and tradition that its ban is justified. It's funny what makes this you can see both sides of Bruen in this case specifically, is that this 11-judge en banc panel heard and decided Duncan before Bruin came down, and were willing to assume, without deciding, but they assumed, yeah, magazines, even magazines that are capable of holding more than 10 rounds, are arms. So we're going to apply Second Amendment scrutiny. Oh, intermediate scrutiny, of course, and we're going to uphold it. Well, now that we're back down, they're like, wait a minute, we're going to spend an entire hour of oral argument discussing over whether LCMs are arms, and we have to go to the second step, the history and tradition test. And that is what's interesting, in my opinion, to see the difference, both by the way the state is arguing, because the state also was willing to at least assume they were arms. Now the state and the court is really doing a lot of work to fight against the clear conclusion that magazines that are necessary to semi-automatic firearms functioning are arms entitled to protection.
Well, yeah, and definitions matter, right? They matter for a very specific reason. And, observing this oral argument, it really seemed like it came down to two primary topics that these judges wanted to talk about. One of them seemed to have to do with context within the case itself, and I wanted to hone in on that because that's based in definitions as well. It seemed like they were really trying to separate the words dangerous and unusual. Now we've seen that that phrase in Supreme Court decisions before. It's not dangerous or unusual, it's dangerous and unusual. Can you tell me exactly what the state has to benefit by changing that definition and what the history of that phrase is?
The state, ever since the case came back down from Supreme Court, then again down from the Ninth Circuit and back to Judge Benitez's courtroom, has been pushing for a dangerous or unusual standard, or something they're also kind of calling unusually dangerous. Some of the judges seem to have fallen for that argument yesterday, where they're saying, no, it doesn't really mean arms need to be dangerous and unusual. They need to be dangerous arms or unusual arms. It was just a faster way of saying it. And that I think benefits folks who want to say, especially for magazines over 10 rounds and arms and semi-automatic rifles that have been called assault weapons in a lot of states. It allows them, by doing that, it makes it so, because we know that magazines over 10 rounds and so-called assault weapons are some of the most highly possessed by law-abiding citizens in the country. So if you take away our argument that they're in common use for lawful purposes, and say, well, they're just unusually dangerous, or they're super dangerous guns, well, then the court can say, well, then you don't have the court can either say what looks like the Ninth Circuit wants to do, which is to say these aren't protected arms at all, and so we don't need the state to tell us if there's any historical analogs to support and justify the law, or they can say, well, history and tradition, even if we do get to the history and tradition test, well, there's a history and tradition of highly regulating unusually dangerous arms, or dangerous or unusual arms. And that's why they kept bringing up yesterday, they kept bringing up the Bowie knife issue, and crossbows, I think, was the one that the state kept
that seems like it can be pretty detrimental to the Second Amendment community when it comes to litigation. If they're able to separate dangerous and unusual, I mean, these are things that they're categorizing, correct me if I'm wrong, that they're categorizing as something that's not protected under the Second Amendment to the Constitution. I mean, you could kind of identify any firearm as dangerous if you wanted to, right? So is that, I guess, at the end of the day, a path for them to banning all firearms?
If that's what you're going, if we take away the unusual part, the common use part, then yeah, I mean, certainly, because they keep talking about, well, we didn't really need more than 10 rounds, and actually it's only like 2.1 rounds. So we can get down to a point, and Judge Benitez brought this up during the motion for summary judgment hearing years ago, in this case, which is, well, then what is to stop the state from saying, well, you can only have one revolver, or you can only have one gun that can only hold 2 rounds? That would be something. I mean, it is that kind of slippery slope, and I would hope that would never get there. But if you do accept that you can pull apart dangerous and unusual and say it only needs to be dangerous because the government said so, well, then then what real justification is there to stop the government from restricting it? And I think Aaron, during oral argument, handled it really well in trying to push the court to understand that it has to be dangerous and unusual. From the reading of Heller itself, it was talking about a historical tradition of regulating the possession of arms that are highly unusual in society at large. And so to say that the unusualness doesn't matter, I mean, it completely thumbs its nose at Heller itself.
Well, speaking of things that Aaron had to deal with during that oral argument, it seemed like it kind of came out of left field, actually ended up sparking some fiery conversation between a couple of the judges.
Why do you think this is unusual? We've been doing it this way for over a quarter of a century in countless cases. Senior judges stay on after a remand, either from the Supreme Court or from the district court.
I totally disagree with the premise of the question.
Well, let me go on.
Different dynamic.
I'm sorry, did you say every other circuit what?
No other circuit has the same dynamic that this circuit has of not having all active judges participate in en banc proceedings.
Right, we have a limited en banc, but in terms of where the case goes back, who hears it, and whether senior judges stay on it, every other circuit does it pretty much the same way.
Every other circuit doesn't do it our way. That's the point.
Judge Nelson, I'm sorry, you can ask the question, but I think it was
I'm
asking
responding to a statement by another panel member that's not accurate.
First of all, before we even get into the jurisdictional portion of this, those judges going back and forth in kind of a fiery way, is that something that you expect from a Ninth Circuit en banc panel, or at least going in on this specific topic?
Fiery exchanges between the judges on the bench, I would not generally expect to see. In this case, I was not super surprised. As your viewers probably know at this point, this case has had an interesting procedural route, and there were some extreme dissent. I mean, well worded, in my opinion, but there were some dissents that were really clear that they opposed what the majority en banc panel was doing by taking Duncan back en banc immediately instead of allowing it to go through the processes that it should, which is the 3-judge panel, then a vote for en banc. Instead, they just went straight en banc. And there were some dissents that were like, this is inappropriate and we don't think you should do this. And, I like to say they were spilling the tea on what was going on behind the scenes that we don't normally get to see. And so I expected that there was some strong opinions amongst the judges about that issue. I didn't quite expect that it would come to head as much as it did yesterday. Which, if you saw my facial expressions during the hearing, you can tell that was a little surprising. But I did expect that there are some deeply held, strong viewpoints on this case, not only in the procedure, but also obviously about the substantive merits.
Well, before we get into, the actual context of that, I'm also kind of curious, and this is where I think it's really easy to lose a lot of people, like myself included. You have a case, Duncan v. Bonta, that is about the state's ban on magazines that can hold more than 10 rounds. You watch an oral argument of state's attorneys and our attorneys going back and forth for a little over an hour, and not a whole lot of that discussion is actually on the magazine ban. Can you describe to me exactly what these oral arguments are for, and why they would be even talking about something procedural like that?
There's a couple things. So I think it's important to recognize the kind of the goal, the focus of oral arguments is for both the parties and the courts to discuss the things that maybe are not really clear from the briefing or the research or the case law. It's to kind of test what, if the judge still has something that they're thinking about, like, what is it, this one sticking point that I need help guide me to my decision on this. That's what oral argument is about. And so what a lot of times you don't see, or you shouldn't see, I think, from a good oral advocate and the Ninth Circuit or anywhere, is just a rehashing of all of the arguments in the brief. Instead, the parties will identify what some of their strongest points, their opposing parties' weakest points, and really address just those. And the judges will bring to the oral argument their questions that they have specifically for the parties. And so a lot of times you don't get into the entire, an entire overview. You have very nitty-gritty questions about small particular points of law. And in that's just normally how oral arguments are supposed to work. In this specific case, we ended up having a very detailed discussion about procedures that has nothing at all to do with the Second Amendment question at hand, the magazine ban. And that's because, again, because of the wild ride procedurally this case has taken to get to this point. Like I mentioned earlier, there were some vociferous dissents about the en banc panel resuming and reconsidering this case at this point. And so it became a question of whether or not it's called Section 46. It's a congressional law. It's a federal law. And the Ninth Circuit's own general orders, the way that the Ninth Circuit internally proceeds with cases, how those work together to take a case like this one that's been going up and down the Ninth Circuit, up to Supreme Court, back down to the Ninth, back down to the District Court. And so how and under what circumstances can this en banc panel hear that case again? And so that case, that could be determinative in this instance about whether or not this court even has jurisdiction to hear the case and decide on it. Which is why it became such a sticking point yesterday, because the court may decide that it can't even decide the merits at this stage.
So I guess, I mean, what are so there's several possibilities that you can go to from here, right? It could go, if I understand correctly, it could go back down to the Ninth Circuit 3-judge panel. It could stick with this panel. It could have a new panel drawn as an en banc panel. I guess, what are your final thoughts for the way oral arguments went here? And what are your thoughts moving forward with what could potentially happen?
First, with regard to what could potentially happen based on this dispute about Section 46 and the court's general orders, we could see that this en banc court will decide procedurally. We can't decide it now, and it could go back down to a 3-judge panel, which would have been the appropriate course. And I think that comes up in the CRPA's briefing to the court, that would have been the correct course. Or, and another correct course would have been, well, the full Ninth Circuit could have taken a new vote to decide to go straight en banc. It didn't have to go to this en banc panel, but they could have taken another vote to have another en banc panel impaneled to decide the case, and that's an option. Another option that one of the judges on the court kept pressing yesterday was, for the first time in history, to take this case full en banc. Ninth Circuit is different than other circuits because it is so large. It has a limited en banc process. Only 11 judges hear it instead of the full court. But there is a procedure for the full court to hear it. And that is an option. And while the CRPA and the other appellees weren't asked to brief about that by the court, and it kind of just came up in oral argument yesterday, it would be the court's prerogative to do that, and it would get us some finality a lot sooner than if we were to go back to the 3-judge panel. But again, either way, I don't think, no matter who is on the losing side of this panel decision or this en banc panel decision, it's going to go to Supreme Court. We're going to seek, someone is going to seek cert on this. It's too important of an issue. With the way oral arguments went yesterday, I feel like the panel is similarly divided as it was last time this case was before that en banc panel. Though we may see some of the more moderate judges kind of come to a place where maybe they want to decide it on the procedural merit issues, or they may come over and decide, now that Bruin has been heard, we have to do the history and tradition based test. I'd be hopeful that would happen, but I'm not holding my breath.
Well, something that that's certainly worth following along for. Anna, I know that you are super busy. I want to thank you for your work on this case, and thank you for coming on.
Of course. Thank you for having me.
Absolutely. And guys, if you like content and want to continue seeing these videos on Second Amendment litigation, legislation, and what is going on with the culture, again, please hit that like, share, and subscribe button. Hit the notification bell so that as we have oral arguments, as we have decisions with this litigation, you are the first to know. Thanks again, guys, and we'll see you on the next one.